Trinity FLAC aims to advocate for reform in areas of the law which are unfair or discriminatory. This week's event seeks to highlight the inequalities prevalent throughout the criminal law. The criminal justice system is the area of law with the potential to have the most serious consequences on the lives of individuals, both by virtue of the severity of the issues covered and the seriousness of the consequences for those who become wrapped up in it. We are joined by an incredible lineup of speakers. First, Fiona Ní Chéiníde, Executive Director of the Irish Penal Reform Trust, will give an overview of the injustices of the system and look at the disproportionate punishment of certain groups. Next, Ivana Bacik, Senator and Reid Professor of Criminal Law, Criminology and Penology at Trinity College Dublin, will look at gender inequality in the criminal law. Jane Mulcahy, PhD scholar at UCC, studying the post-release supervision of long-sentence male prisoners, will then speak on the pains of a punishing childhood. Finally, Coleman Dennehy, Research Associate at UCD, researching history and criminology, will analyse the class underpinning of the criminal justice system from a historical perspective. We hope that you enjoy this event, and we would like to sincerely thank all of our guests for taking the time to participate.
Hello, so my name is Fiona Ní Chéiníde and I am the Executive Director of the Irish Penal Reform Trust. I'm delighted to be giving this presentation for TCD FLAC. You're among my favourite student societies in the country, and I ordinarily love going in and doing this in person because I love the Q&A where you get to challenge IPRT positions and my opinions, and I always learn from the students. But COVID-19 and 2020, it is what it is. So we will make our best of this. So to tell you a few just outline who we are and what we do. So the Irish Penal Reform Trust, we're a small civil society NGO. We're around 26 years. We're a team of 5, and we like to believe that we punch way above our weight. Our work is informed by 2 key principles. The first is that it's the deprivation of liberty that is the punishment, and prison conditions cannot be used as further punishment. The second principle is what we call penal moderation. So that's about prison is damaging in itself, and the negative impacts of prison mean it should only ever be a sanction of last resort. So reserved for the most serious offences and for those offenders who continue to present a serious risk to society. So the first argument, the human rights argument, has been won insofar as Ireland has signed up to a wide number of human rights treaties and obligations in that regard. So our work is not to win that argument, but in terms of monitoring and tracking whether those human rights are being met. The second argument, that prison should be used sparingly, is the argument that we have to go out and win again and again every single day. And this is due to the low public awareness of the realities of prison, of who is in prison, and of the limited role that prison can play in terms of public safety. Instead of improving public safety, prison most often only compounds all the factors that contributed to offending in this first place. And I'm going to talk to you about this in this presentation this evening. So to explain, prison is damaging in itself. It damages individuals, families and communities. And what we mean by that is when a person goes to prison, it interrupts connections with housing, with employment for the very small percentage of people who go to prison who are already employed. It can interrupt relationships with families, with communities. Maybe if somebody was already in a process of treatment or engagement with mental health addictions or health treatment in the community, it interrupts that cycle. And a person goes to prison, and at the end of that period in prison, all those pieces need to be put back together again by the state. And because of this impact is why we say that it should be a sanction of last resort. Additionally to this, it of course has a disproportionate impact on certain communities, not all communities. So to talk you through a little bit about who's in prison today. So there are 3,760 people in prison in Ireland this week. Of those, around 150 are women. They're across 2 prisons. Of the 3,760, about 370 are serving life sentences by definition for the most serious offences. About 400 to 450 are serving sentences relating to sexual offences. Around 700 are detained on remand, which means they are pre-trial and they have not yet been found guilty of an offence. 5 to 10 would be immigration detainees. IPRT's position, and indeed human rights opinion, is informed opinion, is that immigration detainees have not been charged with nor convicted of any criminal offence and should not be in prison. And then the remainder are everything in between, with high numbers of people serving sentences for shoplifting, theft, property offences, and also for drug offences, among other categories. So, who's in our prison? Well, the prison system, I should say. So the prison population is generally characterised by very, very prevalent features. So for example, mental health issues is very high prevalence of people with mental health issues, right up to the most acute severe psychiatric end. So estimated at up to 40% of males and up to 60% of females. And in fact, those figures relate back to a 2005 study. We need to see that study conducted again, but there's common acknowledgement that the presentation of mental health issues among the prison population today there's more of it, it's deeper and more complex and more challenging to deal with. So that's a huge concern. And IPRT certainly feels that there are people, or no, not that we feel, we know that there are people in prisons today for want of community-based services, and that is just wrong. In terms of addictions, an estimated 70% of the whole prison population, rising to about 85% of the female prison population, have addictions issues across alcohol and illegal drugs. And legal drugs as well. There's low literacy and educational attainment. So a survey that IPRT conducted in prisons in 2016 found that 50% of the prisoners who responded had left school before their junior cert or intercert as applicable, and over 20% had not gone to secondary school at all. And this is replicated actually in a very recent study published by the Central Statistics Office, and I would invite all of you to go and look up the wealth of data. So what the CSO looked at was the outcomes in terms of education and work and earning salaries of people in the 3-year period following imprisonment, and it's very stark. You know, it just repeats what I just found. 56% hadn't even done their junior cert, 1.2% had achieved third level university level qualification, and fewer than 10% were in stable employment 3 years after release from prison. But we'll return to that as we go on here. So other characteristics of the prison population are, backgrounds of severe socio-economic deprivation. Shocking statistic is that you are 25 times more likely to go to prison if you come from one of 6 specific electoral districts in Ireland, which are in urban centres. You could predict where they are. High rates of homelessness. The number of people declaring that they were of no fixed abode on committal to prison doubled between 2014 and 2018. And indeed, the homelessness, so this is one of the most damaging cycles related to prison, where securing, you're less likely to be able to attain and maintain stable accommodation and release from prison, and women in particular are 4.5 times more likely to experience difficulties in getting accommodation on release from prison. So it's really challenging. Poverty, chaotic family backgrounds, experience of trauma are all very prevalent among the prison population. Pretty shocking statistic that I was shared at a conference just this week is that up to 90% of women in prison have experienced physical or sexual violence. And we also know there's an overrepresentation of ethnic minorities in prison. So traveller women, for example, make up 22% of the female prison population, which is clearly disproportionately high compared to the general population. There's an overrepresentation of disabilities across all forms, so psychosocial or mental health difficulties, physical disabilities, neurodiversities, and intellectual disabilities. There have been no recent prevalence studies in that regard, but the last one conducted estimated that 30% of the prison population has an intellectual disability. That could be in response to experiences of ACEs and trauma, multiple factors, as a child and through early development. Also, there'll be very high numbers who have acquired brain injury and also have been victims and witnesses to violence from early ages. So these are the most common features across the prison population. So our clear position, by our, I mean the Irish Penal Reform Trust, is that prison cannot and does not solve these problems, with the possible exception of educational disadvantage. So taking mental health, as a starter. So, prison is not a therapeutic environment, it is a custodial environment. And this was stated that clearly by the Director of Care and Rehabilitation just 2 days ago at the National Disability Authority National Conference. So it's a completely inappropriate environment with somebody with severe mental health difficulties, and it only exacerbates those issues. So this is one of the chief concerns that we have. On a positive side, in this year, there is finally a cross-departmental Department of Health, Department of Justice task force has been set up to look at this issue and to explore gaps in law, avenues by diversion, just ensuring that no one ends up in prison for reasons of mental health issues alone. And for those people for whom prison is appropriate, that there's adequate mental health treatment. And that ranges, across the spectrum. So not only psychiatric care, also psychology services, peer support, counselling, well-being, the whole spectrum. Okay, in terms of addictions, well, it's a mixed picture here. So prisons, there are some people who have encountered hard drugs for the first time in their lives while in prison. So they don't have an addiction, a serious addiction going in, and they do going out. But there are other people who do manage to conquer their addictions during the time they're in prison, but then they're released back out the door with 2 nights in a hostel, maybe with or without other users in that room. So, we need to just pay more attention to how we support people who work hard to overcome these challenges, and make sure that on release from prison, we support them with an environment that will help them achieve their own personal goals, which is to move on from offending behaviour. So, again, but nobody should be in prison for want of a residential drug treatment facility in the community. So that is an enormous issue. In terms of poverty and unemployment, well, it'll come as no surprise that prison does nothing to address either poverty or unemployment. Indeed, the stigma and challenges and barriers attached to a criminal record increase the likelihood of unemployment and make it more challenging for people to find work. So that is a vicious circle of social exclusion and crime. IPRT is working hard on improving schemes whereby certain convictions no longer have to be spent after a set rehabilitative period. And I would welcome all of the FLAC Society members considering making a submission to the current Department of Justice consultation on that. Our deadline is November 6th at midday, and I'm not sure if this video will go out before that, but it's certainly something that we need to pay attention to. In terms of disabilities in prison, so there are 2 issues here. One is that the prison system, the physical and whole prison environment, is widely inaccessible to people with disabilities. The state and the Irish Prison Service are under obligation under the UN Convention for the Rights of Persons with Disability, and also under the Human Rights and Equality Act, so the public sector duty to ensure there is reasonable accommodation for people with disabilities in prison. At the same time, IPRT is concerned and clear, prison must be a sanction of last resort for everyone, and that includes people with disabilities. And we do not want to see a situation where prisons must meet the requirements of people with disabilities and make those reasonable accommodations, but prison should never be the best or only place where anyone receives the wraparound services and secure housing that they need. You know, it must be based on the gravity of the offending and not on social needs. In terms of trauma, we would wonder whether prison can ever adequately provide trauma-informed care. We do welcome that the Irish Prison Service, and particularly prison psychology services, are committed to the provision of trauma-informed care, particularly among the women's prison population. But, you know, the core elements in relation to trauma-informed care in terms of choice, agency, autonomy, all of these things are taken away by a prison environment, which is by definition all about coercion, control, force, and stress. So while we appreciate and, you know, we welcome the responsiveness of prison psychology in this regard, I think there is something fundamental in the structure that we wonder whether it can be adequately achieved. And then the last area, as I described, is education. And this is one area where prison can make a difference. There are many people who receive their first positive experience of education in prison. They do their junior cert, they do their leaving cert, they might start third level, they might continue on to master's level after they're released from prison. And education is truly transformative. However, saying that, no one should have to go to prison to have a positive educational experience. I mean, this is very clear, and it's, you know, it's catching people who fell through nets, you know, that should have been responded to when they were very young, you know. So in that regard, you know, school retention policies play a role in ensuring people don't end up in prison at the other end. So it's also a question of where we invest. You know, we need to invest in communities, early education, prevention, early intervention strategies. These are all better for, they're less damaging, less harmful, better for communities than prison. So actually, on that note, just to make a note on victims, you know, because nothing we say we never want to, and we never mean to, undermine the impact of crime on victims. And we are clear that people who cause harm must be held accountable for that harm they've caused, but they must be held accountable in a way that does not cause further harm. And that's the key piece here. And it's also very important that an emphasis on rehabilitation, well, crime prevention, but also rehabilitation, is not a liberal view that gives prisoners a soft landing. It doesn't undermine the rights of victims. And I'm going to quote the former Northern Ireland prisoner ombudsman, who says, well, put simply, it is imperative that the prevention of reoffending is at the heart of a victim-centred approach and the development of a safer society. You know, this will ultimately instill confidence in victims and the general public that crimes will not be committed. And this is in everybody's interest, including victims, that prisons don't compound issues, but that they work to address the issues that cause the offending behaviour in the first place. So in this light, failure to address the most urgent human rights issues in prison today is failing people in prison, failing prison staff, and ultimately failing public safety. So what are the most grave human rights issues in prison today? Well, going back to mental health. So there are, on any given day, 25 to 30 people in prison who are awaiting transfer to the Central Mental Hospital. This is because they have been assessed as in need of urgent transfer. And the waiting list, the waiting times, is on average 120 days. It can be as little as not as little, it can be 7 days, but it has also been more than 504 days. So, you know, this is just a scandal by any measure. We're also very concerned about the conditions experienced by people who are awaiting transfer to the Central Mental Hospital. We don't know, for example, whether they're spending long periods of time in segregation or in isolation. And, you know, we know that prison staff, particularly in Clover Hill Remand Prison, do everything that they can to help people, but it just doesn't get aside from prison staff are not trained psychiatric nursing staff, and they should not be required to look after people who ultimately should be in appropriate therapeutic facilities, not prison. We're concerned that there are, well, at the last time information was published, there were 75 men in solitary confinement and in the region of 350 locked up for 21 hours or more per day. So approximately 14% of the prison population were on restricted regimes before we entered the COVID-19 pandemic and all the impact of restrictions in prison. We also know that solitary confinement, which is lockup of 22 or more hours a day, it has been found after 14 or 15 consecutive days to have, it's defined then as prolonged solitary confinement, and the UN and the Council of Europe have noted that it can have irreversible psychological consequences for a person. So a big campaigning issue for us is that it should end. And also bear in mind, when I'm talking about people in solitary confinement, everything I said about the high prevalence, the existing high prevalence of mental health, addictions, disabilities, experience of trauma, experience of violence, and then imagine that you're in a cell for 22 or more hours a day in isolation and the impact that has. So moving on to more fun stuff, slopping out continues in 2 prisons in Ireland. In Limerick Prison and Portlaoise Prison, this is a significant reduction. So about 55 or 58 men are slopping out in prisons today. It should not happen anywhere, certainly in a rich, wealthy West European country to the 21st century. But we do acknowledge that this is a significant reduction in the last 10 years, and the building work is underway to moving towards absolute final abolition of this practice. Overcrowding persists as an issue. In January, February this year, 5 of 10 closed prisons were overcrowded, and there were 75 people sleeping on mattresses and floors across the prison system. Now, that has been reduced in response to COVID-19. The prison population was reduced, and we welcome that, but we certainly cannot see a return to that during COVID-19 or after COVID-19. Other issues: prisoners do not have access to an independent complaints mechanism, which is an essential protection against potential human rights breaches behind bars. And worryingly, there's been no inspection report of a closed prison published since 2014. So we really don't know how things are. And there's a lot to do. So what needs to be done? The first thing we need to do is reduce the numbers in prison and overcrowding in prison through increased use of alternatives to prison. A shocking statistic is that we believe is that in 2019, 76% of committals to prison under sentence were for sentences of less than 12 months. Now, this needs to do, so this is by definition for less serious offences, low level, persistent offending, shoplifting. Again, we don't want to minimize the impact of the crimes, but what we do know is that community service and integrated community service responses, restorative justice, non-custodial alternatives are proven to be cheaper and more effective and less damaging responses to less serious crime. And we do not understand why Ireland continues to send more people to prison for short sentences than it does hand down community service orders. We're also mindful that community service has been found on one regard, it gives structure to a person's job, and people who might not have experience of employment in the past view community service as kind of a way of getting work ready, which is very positive. And at the same time, the community benefits from an estimated €3 million worth of unpaid work in the community every year by people carrying out community sanctions. So it's a win-win for everyone, and we need to know more. So we've called on the Department of Justice to really examine why the courts continue to hand down short sentences. A phenomenon which is also dismaying is what's called life by installment, and it's particularly a feature of the female prison population, where a woman can spend 2 or 3 or 4 decades of her life in prison, but serving short periods of 3, 4, 5 months sentences in and out, in and out, in and out. And the only place where she can access safe, stable shelter and wraparound services is in prison. And there is no more damning indictment on society when anyone chooses prison over the community because they feel safer there. So moving on, more cheerful stuff. We need to stop detaining people with serious mental health issues in prison and ensure they are treated in appropriate therapeutic settings. We need to eliminate solitary confinement completely. There are, it's very clear that, a person's physical safety should not be protected, with impact on their psychological safety. I mean, this is really clear, and also maybe taps into the conversation we're all having at the moment about COVID-19. And we accept that the protection of life and physical health is extremely important, but the state is obliged to meet the highest standards of both physical and mental health, and these must be achieved at the same time, not one at impact on the other. We need to ensure that all prisoners have 12 hours out of cell time every day, including at least 5 to 7 hours engaged in meaningful structured activities such as work or education or training. And we need to introduce single cell occupancy across the prison estate. This builds better and safer prisons at the best of times, but certainly during COVID-19, when it has a direct link to how we can keep people safe. So other things we need to see happen, we need to improve accountability across the system. So we need to ratify the optional protocol to the Convention Against Torture. You can look that up after this presentation. We need to resource the Office of the Inspector of Prisons and reform the legislation so that the inspector can publish reports directly, and it's not the Minister for Justice who has the ability to redact those reports. But in our experience, that is a power that is not exercised. But what's important here is strengthening the powers of the Inspector of Prisons, and we need to ensure prisoners have access to a fully independent complaints mechanism, including the ability to appeal to the Ombudsman. This is incredibly important because there is little or no confidence in the internal prison complaints mechanism at the moment on the side of staff or of prisoners alike. So we need a system that everybody has confidence in. And this is crucial to protecting access to rights and human rights and prevention against torture and ill treatment in prison. And again, going back to that profile that I set out at the top of the overrepresentation of mental health issues, addictions, educational disadvantage, being a member of an ethnic minority, experience of trauma, experience of violence, all of that means that we owe it even more to the people in prison. So we have to do so much more to prevent individuals, families and communities becoming trapped in cycles of disadvantage and imprisonment. And again, we don't mean this to undermine the impact of crime on victims. It's really important that people who commit serious offences and present an ongoing serious risk to the community, prison can be appropriate in those respects, but for all other categories of offence, for less serious offending, community-based sanctions are less damaging and don't contribute to the vicious circle of social exclusion and crime. So, in short, we have to make sure that meeting human rights minimums are not a target of a wealthy country such as Ireland, but a step towards achieving international best practice in our penal system. And, above all, the penal system has a role that's the broader penal system, has a role in addressing issues of social injustice. And I hope this whistle-stop tour through IPRT's work was of benefit to the FLAC Society. Do please look up all our information. It's on iprt.ie, and we have another big information project on prisons, which is pips.iprt.ie. So that's pips.iprt.ie. And please follow us all on Twitter. Engage, challenge us, retweet us. We'd love to make contact and see you hopefully in person next year. Thank you.
I'm delighted to talk for FLAC about injustice in the criminal law, and specifically about women and criminal law. It's a subject that I've always been hugely interested in, and I'm delighted to have taught feminist criminology for some years now in Trinity and to be researching in that area. So the subject of women or gender and crime was neglected, or relatively neglected, by criminologists right up until the late 20th century, although a significant body of research has been generated by feminist criminologists since then. New directions in feminist criminology in recent years have been opened up with a growing interest in exploring the gendering effect of the law and the relationship between gender and crime. The original feminist empirical question has been reversed. Instead of asking, as feminist researchers did in the 1960s and 70s, why so few women committed crime, the question has been turned on its head, and now criminologists seek to understand why so many men commit crime. What is it about seeing offending through the prism of gender that can teach us things about crime? An approach to crime which looks at both male and female offenders through the prism of gender is a useful one. And this approach analyses the social construction of gender and indeed looks at intersectional differences as well as gender, looking also then at ethnicity, at sexuality and at class issues, as well as gender and sexuality, and looking, of course, at the way in which construction of genders contributes to criminality. Research also continues, of course, into the impact upon women specifically of some areas of criminal law, notably areas around rape law and domestic violence, and I'll speak a bit about those. Because in recent years, largely due to feminist and activist campaigns, we have seen significant changes in our criminal law in regards both to rape and sexual crime and also to domestic violence, so-called domestic violence crime. In Ireland, in the last few years, we've seen the passage of the Criminal Law Sexual Offences Act 2017 and the Domestic Violence Act 2018, both of which made significant changes. Problems remain, however, in particular around cultural perceptions of rape and of domestic violence, and around attitudes and what we call rape myths when we look at rape law. And indeed, much work needs to be done still in reforming this area. Some years ago, along with colleagues in Trinity, Catherine Monsell and Sue Gogan, I conducted a study into the rape trial process and its effect upon complainants or victims in the courts. This was an EU-funded study. We looked at different European countries as well as Ireland. We published in 1998, and we made various recommendations about how trial procedures could be reformed to ensure that the trial was not just a second victimisation. Because what we found, and indeed what other research had found consistently, was that rape trials were highly difficult, highly victimising of those women who had involved in them as complainants. We recommended in particular that a woman who makes a complaint of rape and who is then a witness in a criminal trial should have an entitlement to separate legal representation, in particular where the defence seeks to put in play evidence that she has had sexual experience or sexual intercourse with the defendant or indeed with anyone else, evidence that is in fact possible to admit in court and which has had a significant prejudicial effect upon victims over many years. And indeed, again, we see a body of feminist literature that is critical of this evidential rule. I'm glad to say our report led to statutory reform in 2001, which did provide for a separate legal representative for a complainant in a rape case where the defence seeks to bring in prior sexual history evidence. But this is a reform which, while it has done something to improve the conditions for women and indeed for male complainants in rape trials, nonetheless hasn't done enough to change the culture in which we see victim blaming and the spreading of rape myths still as prevalent. And indeed, just 2 years ago in 2018, with the Belfast rape trial in Northern Ireland, and in this jurisdiction with reports about a barrister asking about underwear a woman complainant was wearing at the time of the rape, we've seen significant public concerns raised again about the extent to which we still have these sexist and indeed often misogynist rape myths and about the impact they have on the outcome of rape trials. And we know that convictions are harder to secure in rape trials than in other criminal trials. Those two very high-profile cases have generated some new research and indeed new recommendations around further reforms that need to be introduced. And we've also seen, as I've said, the Criminal Law Sexual Offences Act 2017, which again did bring in some new procedural safeguards that have been very welcome. In particular, the 2017 Act for the first time introduced into our law a legal definition of consent, stating that a person consents to a sexual act if he or she freely and voluntarily agrees to engage in that act. The first time we've had a statutory definition of consent in law, something for which we as feminist legislators and rape crisis centres had also been campaigning for many years, and that is very welcome. We've also seen recent publication of a report by academic Tom O'Malley, academic and practitioner and a noted expert in the area of sex offence law. He chaired an interdepartmental review on the investigation and prosecution of sexual offences, and this reported to government just at the beginning of last month. And it followed, of course, the Northern Irish Gillen report, which again was set up to look at procedural safeguards for victims in the wake of the Belfast rugby rape trial. The O'Malley report contains a range of important recommendations, including the need to ensure sensitivity training is provided for legal professionals and frontline workers. And he also recommended the making of an offence where the publication of names on social media occurs during a trial, an increasingly significant issue in many trials. He also suggested and recommended that pre-trial hearings would take place so that victims are not forced to disclose intimate details of their sexual history during the course of a trial without adequate and effective warning. Some of the measures that Tom O'Malley recommended will require legislative change. Others, however, are just about changing court practice and trial rules. And the Minister for Justice and Equality, Helen McEntee, has committed to developing a pathway towards implementing the reform recommendations later this year and hopefully by the end of October. This is very appropriate and very welcome, and I know that along with many others in the legislature and indeed through the rape crisis centres and other networks, we'll be seeking to ensure that the reforms are made. I would also be conscious, however, again looking at research that's been done, that we have to challenge ideas around consent, and noted US academic Catherine McKinnon has written very powerfully a critique of the concept of consent, saying persuasively that when we talk about consent, that we're implying a subordination in a relationship, that if we are agreeing as two equal partners to partake in sex, then it's a misnomer to describe it as one party consenting to have an act of sex performed upon them. So I think we do also, within academia, and indeed when we're formulating laws, need to think about what we mean by consent, and indeed how we can improve upon the law and the conduct of trials, so that it's not always the victim who feels she's been put on trial, and it is very frequently a woman, that she's not been put on trial, and that the questioning is not always around her consent, that rather the focus is upon the accused and his behaviour. So more needs to be done in the sphere of rape trials, and indeed the need to dispel rape myths. But aside from those issues, we've seen need for further reforms also on domestic violence law, and in particular during this dreadful COVID-19 pandemic, we've seen real concerns about increased incidents of domestic violence or domestic abuse. Women's Aid report on domestic violence during the COVID-19 emergency recorded a 43% increase in calls between the end of March and the end of June compared to the same period the previous year. And we've seen, of course, increased pressure on emergency refuge places and pressure on courts in terms of having sittings to deal with domestic violence. I have welcomed very much the Garda Operation Fuishiv, which was the Garda developed response to this increased incidence in domestic violence during the pandemic. And the Garda campaign has been a very high profile one. They've sought to contact any individuals who had reported domestic violence in the past to ensure that they were safe and that their situation hadn't worsened during the pandemic. And they've also launched a public awareness campaign, so this is very welcome. In addition, the Domestic Violence Act 2018 did provide new reforms in the area, and in particular, something that we were very proud of doing in the Shannon, we pushed for the introduction of a new offence of coercive control. And we've seen it as a feature of many cases where domestic violence has occurred, that this violence may occur as a physical violence, but there's also an abuse that takes a different form, that is in the form of controlling behaviour, of intense surveillance over usually a woman in her own home, that is a sort of controlling behaviour that is often a precursor to or accompanies serious physical violence as well. So we're very pleased to see a new offence of coercive control introduced in that legislation, and I've certainly attended quite a number of sessions with police and with NGOs looking into how best to ensure that the policing and enforcement enforcement of this offence is effective. We've known far too many women who've died at the hands of their partners in the home, at the hands of abusive partners in the home over the years in Ireland, and this is a really serious issue that requires a great deal of public focus and a great deal of activist focus too. Finally, I want to mention the extensive research that exists in Ireland and elsewhere on the differential treatment of women as offenders within the criminal justice system. We're well aware of the research that's been done, as I've said, on victims of rape and sexual violence, most of whom are women, and the victims of violence in the home or domestic violence, again, most of whom are women. But there's also been a significant body of criminological research looking at how women are treated where they offend against criminal laws. And we know that, for example, in sentencing, women are likely to receive significantly differential treatment to their male counterparts. Again, some research I did some years ago on crime and poverty in Ireland, intersectional research looking at class and gender, found serious differences emerge. Lindsay Black, now in Maynooth, has done a thesis examining the practice of capital punishment in Ireland and looking again at how women convicted of murder were treated differently to men convicted of murder. Christina Quinlan at DCU has also done research on women's imprisonment in Ireland and has found, as Lindsay did and indeed as other research has done, that while women were less likely to be imprisoned than men for the same offences, they were more likely to be coercively confined in institutions outside the criminal justice system. So historically, we've seen women who deviated against a norm, who didn't conform to, for example, social mores around sexuality or social expectations, that these women were incarcerated in Magdalene institutions, in mother and baby homes, or indeed in psychiatric institutions. And there's a really terrible history in Ireland of incarcerating populations, disadvantaged and vulnerable populations, like women who are seen to have deviated from a norm in these non-coercive or non-penal institutions, but which nonetheless had a hugely unjust and harsh effect on the women imprisoned. And we know that the very harsh treatment of women occurred in Magdalene laundries in particular, also in mother and baby homes, and indeed even in psychiatric institutions in the past. It's good that now research is uncovering this treatment of women who are likely often to spend long periods of time, many years of their lives, effectively imprisoned in institutions, and yet who weren't seen as having been imprisoned through the criminal justice system. So in this sort of historical research, just as in the research we're doing on improvements to trial procedures for rape and for domestic violence, we are still continuing to bring a feminist perspective to bear on crucial questions of criminal justice. And I know with FLAC, with the Free Legal Advice Centres, you and everybody involved in FLAC has always brought a very critical perspective and a very questioning perspective to bear on aspects of criminal law, and I hope you'll continue to do so, and I look forward to working with you on questions around women, around gender and crime, and questions around injustice and crime. Thank you. Guramagra.
Hi there, my name is Jane Mulcahy and I am going to be talking to you today about the pains of a punishing childhood. So the graphic on the screen is of a tree, and at the roots of the tree are things like poverty, discrimination, community disruption, lack of opportunity, economic mobility and social capital, poor housing quality and affordability, and community violence. Wendy Ellis from the Centre on Building Community Resilience in Washington, D.C. calls this graphic the pair of ACEs. So ACEs stand for the adverse community environments, the roots of this tree, and also for adverse childhood experiences, the things at the branches of the tree, things like maternal depression, emotional and sexual abuse, substance abuse, domestic violence, homelessness, mental illness, divorce, physical and emotional neglect, and incarceration. These are things that can happen within the home and can have a harmful impact on us. So the Adverse Childhood Experiences study from 1998 was a large-scale epidemiological study, a partnership between Kaiser Permanente and the Center for Disease Control in America. And what it showed was that adverse childhood experiences were very, very common among a population of mainly white middle class people who were college educated and could afford expensive health insurance. So the ACEs that they studied in this original investigation were abuse that was physical, emotional, and sexual, physical and emotional neglect, and 5 types of household dysfunction, including living with someone with a mental illness, or someone who was incarcerated, someone who had a drug problem or alcohol problem, living in a household where the mother was violently abused, and having parents who were separated or divorced. And what the study found was that these adversities were extremely common. Over 60% of those surveyed had one of these adversities, and about 12% had 4 or more of them. And the key finding from the study was that the higher the ACE score, the greater the risk of experiencing poor physical and mental health and negative social consequences later in life. So one of the criticisms of the study is that it's deterministic, or it tries to apply population level findings to individual cases. But the evidence is actually very strong, because there have been subsequent studies all showing that the higher the ACE score, the greater the risk of heart disease, cancer, high blood pressure, compromised immune function, the higher the level of risk of becoming an alcoholic. I mean, the risk increases to 700% if you have 4 or more ACEs. And the same with the risk of attempted suicide, it increases by 1200%. So these statistics are not to be sniffed at. The quote at the top of the screen here is, "It's just numbers and stats till it's your life." And it's by a chap called Nyler, a hip hop performer. He used the IPRT's report called "A Vicious Circle of Social Exclusion and Crime, Ireland's Disproportionate Punishment of the Poor," in his song, where that phrase, "it's just numbers and stats till it's your life," was used. There were other reports about suicide and mental health, and stats from the Irish Prison Service also used. But the essential point is this: we cannot flourish as human beings if we don't have our basic needs met, if we are so poor that we are not fed, if we cannot sleep at night because we're living in a violent household, if we live in an unsafe place like a B&B or a direct provision centre or a halting site where there's community violence around us. If we are on edge all the time, we cannot think about self-actualization or even love and belonging, because we're in survival mode. The other 2 pyramids are to do with the adverse childhood experiences studies and the importance of including historical trauma and things like the legacy of slavery and colonialism into our thinking and understanding of people's problems. And in the context of Ireland, with the travelling community, who are an oppressed minority, whose way of life has been nearly obliterated by the state, we need to understand individual and group struggles in this context, because flourishing is very difficult when we're excluded from the world and constantly fighting to just survive. So my PhD essentially argued that we need to connect corrections, so prisons and probation, and also we need to correct connections to the self and also to understand brain development, because we're all essentially the same in terms of what we need to thrive in life. We need to feel safe and secure, and we need to be nourished by our primary caregivers. We need to have ample hugs and kissing, because this actually gets our neurons to fire. As babies, our primitive survival brain is very active. It's only once we're born that our attachment brain, the midbrain, the limbic brain, which governs our emotions, develops. And this develops in the context of our relationships. So our relationships with our caregivers, normally our mom and our dad, are the most important relationships for our future functioning. The third part of the brain, the rational part of the brain, our cortex, our neocortex, our thinking, learning, and the part of the brain responsible for language and inhibition also develops in the context of our experiences within our family. And if we're not safe, if we experience trauma and abuse and neglect, we are not going to be able to grow up to function well within the human pack, because human beings are pack animals. We will only survive and have only survived because we can collaborate and be part of a group. And people who experience a lot of trauma and adversity and stressors in their early years find it much harder to be functioning members of the group and to care about the needs of others. Neuroception is a phrase by Stephen Porges about the unconscious detection of safety or threat in our environment. And as babies, if we're safe, this means that we will feel safe in our bodies in the presence of other bodies. And as we grow up, we will trust other people and believe that the world is intrinsically safe and that people are generally good and kind and considerate. But if we don't have that, if we grow up with such danger and violence all around us and no one ever comes to our aid when we're frightened and feeling alone, we essentially have a kind of Godzilla rampaging around our inner world. And as babies and infants, our brain is developing, at such a rapid pace, and neural pruning is happening to make our brain more efficient. There's a phrase, use it to lose it. If you're not using certain neurons, we lose them. And also, if we're constantly stressed, we develop a fixed allostatic load, which means that our cortisol levels, our stress response system does not go back to normal. It's overexcited, it's constantly elevated. And when this occurs, the likelihood is that we're going to develop or overdevelop rather our life-preserving brain. Our survival brain will be firing constantly at the expense of our rational brain. And this will make it difficult for us to concentrate and achieve in school. We might be anxious, disengaged, and unable to learn. I don't know what I've done there now. There we go. Next. So this is a graphic from Stephen Porges about the significance of the vagus nerve, which links our gut to our brain and our heart and our lungs in between. When we're safe, we are calm in our connections to other people, we're grounded, we can be curious and open and compassionate, and we can learn and we can behave well and we can cooperate. If we're frightened, if there's danger, we will become hyper aroused and we will either take flight, we will run away, we'll be fearful and panicked, or we will fight. And this manifests in rage and anger, irritation and frustration. If, however, we face a life threat, if we grow up in a household that is rife with violence and sexual abuse, and we cannot cope with this, so much so that we actually disconnect from our environment, we dissociate or shut down. This is the kind of freeze and collapse state. And this has a massive impact on our functioning over the life course. And in terms of offending behavior and class, really, the point is this, that children become adults, babies become children who become adults. And our safety in our earliest years has an impact on our ability to function and flourish as adults. So people who become prostitutes or homeless drug addicts begin life as innocent children. And the system, the criminal justice system, poorly understands this. And then going back to adverse community environments, trauma occurs within a social context, and we are more likely to suffer higher levels of stress and trauma if we are poor, and if we have a lot of stress in our community, poor housing, mass unemployment, high levels of single parent families, rubbishy education systems. We are more likely to develop post-traumatic stress disorder, a complex trauma, and we are likely to transmit trauma onto our children as adults. So that's my contribution. I hope it was useful to try and bring together the fact that trauma is an individual, but also a social phenomenon. And there's huge levels of trauma in society. But for people who are poor, who might use drugs and alcohol to survive, the likelihood of them becoming involved in the criminal justice system is very high. And we ignore unprocessed trauma at our peril. So thanks for listening. I hope you found this interesting. You can find more resources of mine on ResearchGate, on my podcast called Law and Justice on SoundCloud, and also my How to Talk Policy and Influence People series on YouTube. You can also follow me on Twitter at Jane H. Mull. Hopefully this wasn't too long. Please edit it if I rattled on too long, but I can literally talk about trauma and adversity for hours. Take it easy. Bye-bye. Stay safe and well.
Hi there, my name is Coleman Dennehy. I'm from the Humanities Institute at UCD, and I am a legal historian and a criminologist, and I'm working at the moment on early modern Ireland. I'm writing a book on how crime and punishment worked in the period, and I'm very pleased to have been asked to say a few words about class and society and how that interacts with the criminal justice system in early modern Ireland. I think the first thing probably that we need to take into account is that later medieval and early modern Ireland is very much a hierarchical society. It's the king on the top, the aristocracy, who are themselves broken down into a number of strata, and below them the gentry in the countryside, the townspeople, and again there's various degrees of wealth associated with them, right down to the very lower orders of society. In early modern Ireland, for the most part, everybody is free. There's no kind of villain or serfdom status, and there's not much, as far as we can tell, no slavery in Ireland at the time either. The church also works in a similar fashion, and most of the organs of state are cognizant of this kind of segmentation and stratification of our society. We can see this very clearly at the end of the medieval period, where we have acts in law such as the Scandalum Magnatum, an act specifically protecting magnates or aristocrats or noble people from insult or libel, and also things like sumptuary law, fashion law essentially, which prevents people from wearing certain colours or styles of clothing or materials that are not befitting of their status in life. I think one of the big game changers in Ireland, across Western Europe indeed, two big events at the end of the Middle Ages, the start of the early modern period, the Black Death, which kills off huge numbers of people, and Ireland doesn't escape this either, and it has the effect of reducing the population to the point that labour becomes scarce, and it plays a big part in freeing up this sort of serfdom or villain status, and it gives those people from the lower orders of society a certain amount of freedom, and with that comes power. And I think the state works to try and regulate this after this point, and also in the early modern period in the 1530s in Ireland, the end to the monastic system that is brought about by the Reformation, and this takes an awful lot of land and it redistributes it in our society, and it essentially sets up a sort of a movement, a mobility within property ownership, and this affects how wealthy people might be, and there's losers and winners in this status. And so it's no surprise, for instance, that we see two very important pieces of legislation relating to class and wealth in Irish society. One of which is an act. I actually have a full copy of it here. It's called an Act for Vagabonds. It's passed in the year 1537 in the reign of Henry VIII, and it essentially regulates begging within Irish society. It regulates how aged, poor and impotent persons compelled to live by alms should be ordered, and then the second part, which is a bit scarier, how vagabonds and mighty strong beggars should be punished. And it's very much setting up, and you see this in modern Irish society as well, the kind of deserving poor and the undeserving poor, or the lazy or the idle. This suggests in its opening preamble that idleness is the cause of the increase in begging. Now we know that there's lots of other reasons why we get begging and why people need to resort to that in the early modern period as in today, and it's certainly not down to idleness. In addition to the regulation of begging, for vagrants begging without a letter of permission, we see that they are to be stripped naked and whipped and set in the stocks within the town, and the strong who beg, who are essentially choosing not to work rather than being unable to, should be whipped and returned to their own place. And about 100 years later, in 1536, there's an act passed for setting up a house of correction, which takes the people who are being prosecuted in relation to begging and essentially putting them into what essentially is amongst our first prisons, where the punishment is the incarceration. Now, there are other people who study these institutions in Europe who read them through a Marxist lens, where it talks about having captive labour and work set and the origins of sort of a captive capitalism. And that might be appropriate for Ireland. It's difficult to say with any degree of certainty, but it's very interesting. They define what they call rogues and vagabonds and idle persons in this. And I'll just read from the Act, if you've got the time to listen. All persons calling themselves scholars, going about begging, all idle persons going about in any country, either begging or using any subtle craft, or unlawful games or plays, or feigning themselves to have knowledge in physiognomy, palmistry, or other like crafty science, or pretending that they can tell destinies, fortunes, or such other like fantastical imaginations. All persons that be or utter themselves to be proctors, procurers, patent gatherers, or collectors, for jails, prisons, or hospitals. All fencers, bear wands, common players or interludes, and minstrels, wandering abroad, all jugglers, wandering persons, and common labourers, being persons able in body, using loitering and refusing to work for such reasonable wages as is taxed and commonly given in such parts. For such person do or shall happen to abide or dwell, not having living otherwise to maintain themselves, all persons delivered out of jails that beg for their fees, or otherwise travail begging. All such as shall wander abroad, pretending lost by fire or otherwise, all such wandering as pretend themselves to be Egyptians, by which I understand that to mean a Roman gypsy, or wander in the habit, form, or attire of counterfeit Egyptians, should be taken, adjudged, and deemed rogues, vagabonds, and sturdy beggars, and by this act can be incarcerated in these houses of correction, where they can be put to work in chains to receive some payment for that themselves, but also to generate revenue. And again, at the same time, we see, particularly in the towns, that poverty and crime interact a lot more, because I think probably the wealthy people who create law and administer it and enforce it, and the poor people who are frequently the targets of this. And it's not always the case that it's only poor people who are targeted by the law, but certainly there's a very strong element of that in early modern Ireland. And those people who are targeted, living cheek by jowl in a town within city walls. Most towns in Ireland are essentially medieval towns up until well into the 17th century, with walls, and people are living very close by each other. We also see the prevalence of martial law, where military figures have parts of the country under their control and can essentially execute in a summary fashion without a common law trial poor vagabonds and idle persons, people with less than a 40 shilling freehold or less than £10 goods, which doesn't even make you that poor in early modern Ireland. But the fact that you can simply have a summary execution, I think, goes a long way to illustrating, at least in some fashion, where class and criminal justice interact within Ireland. This greater regulation of the poor, like I say, happens in towns all the more often. From the Dublin Council book in the 16th century, there's an item that no beggar shall beg but of the ward where he dwelleth, and if he be found in any other ward begging, that then the constable of that ward should set him in the stocks for 24 hours. And the strange beggars, those who come from outside the locality, are feared even more by those in power. They're to get 40 days imprisonment and then to pay a fine of some 20 shillings, and then to be excluded from the city and sent on their way. And the regulation within the towns for how you deal with poor people and poor people who break the law or are deemed to have broken the law. We get the use of stocks and pillories. They're those kind of almost cartoon-like medieval punishments and early modern punishments. Put your head and your hands through the board, and people throw things at you. But also whipping, which can be intensely painful. People have died from excessive whipping in the past. The use of cages, putting people simply into cages, it's part of a humiliation as well as that. And the use of ducking stools are used in towns as well, not necessarily against poor people only, mostly used against women, although they can be used by men sometimes. And it's part of a humiliation process, but it tends to be used for sort of women from the lower echelons of urban society who don't know how to behave themselves properly and who are usually speaking out of turn or who gossip or are scolds. So I think that's terribly interesting as well. Do the towns and the courts generally protect the wealthy above the poor? I think it's probably safe to say that they probably do. Not absolutely or all the time, but it does happen. One of the regulations from the town of Kilkenny, very interestingly, gives constables the right to enter people's properties where any whoredom or adultery is committed, and then to commit them to the stocks. But very interestingly, in Kilkenny, it's only provided always that the said constables shall not enter into any Burgess's house before he warn the good man of the house that he's coming in, which obviously negates any sort of element of surprise in entering the property to put a stop to what's deemed to be poor behaviour. The fact that the courts allow for trial by peer for those who sit amongst the aristocracy, a special trial to be judged just by their own people, is in itself probably a fairly good guarantee that there is a lighter form of justice for the peers. Although at the same time we do see at the Court of Castle Chamber the use of a court which is used specifically at times to go after the rich, especially in the time of Lord Deputy Wentworth, the Earl of Strafford, who takes on a number of very significant aristocrats. And for instance, the case at the end of the 16th century where the Lord of Howth is prosecuted for, amongst many other things, excessive domestic violence is excessive, of course, but this guy really is a brute and a sadist, and I'm choosing those words with caution, and I don't think I'm exaggerating. I was wondering earlier whether I should read out exactly the nature of his crimes against his wife and his daughter and his servant, and I chose not to because it's really quite brutal. And a court like that is used specifically to get people like Howth, because you would not be able to prosecute him in regular courts in the locality, such as his influence, because he owns huge amounts of land and he's very, very wealthy. And it's, I think, at least very unlikely that he would have been punished in that sort of a fashion. Then finally, when we look at the actual punishments generally across Ireland in the early modern period, to sort of get an idea of whether they are classist or whether they follow that segregation of society. They probably do. Shame punishments, I think, are probably not going to be used against the great and the good of Irish society. And when we do see them being used, they tend to be used probably against the lower orders or maybe some of the middling sorts. This can be anything from the ducking stool, literally dropping somebody into the river, attached to something kind of like a seesaw, Also, like I say, corporal punishment, it tends to be mostly against the poor. And like I say, that can be stocks. It can be being put into the pillory to stand there. That's half shame and it's half uncomfortable. But there's also people being branded. That's a hot brand being placed against your forehead, your cheek, or into your left hand just there. Also, perhaps people are having their ears removed at the pillory. They're being nailed onto the pillory, and they have to be cut off to be set free. People being bored through the tongue. That's a nail going in through your tongue there. Slit down the nose where your skin will stretch, because it's just it's stretched across that part. In terms of incarceration, aside from the House of Correction, people are either for debt, which is not specifically a crime, it's more of a civil case, but they are incarcerated along with people who are awaiting trial, say for felonies or treasons. And we know prisons are run essentially as private or for-profit enterprises, so people are appointed by the city or by the state. So for example, Newgate Prison in Dublin, which sits on the city walls. If you're going around by Cornmarket beyond Thomas Street, where you cross the walls there, Newgate would have stood on that street. And accommodation within this prison is arranged according to the ability to pay. So if you're wealthy, you can get half decent accommodation and you will be provided for in terms of food and drink. If you don't have much money, you're going down into the dungeon, and those are really quite horrific places. The conditions are most insanitary. Probably a lot of violence there as well, not just from other prisoners but also from those running the prison. Really quite awful. In terms of execution, we have lots of wealthy people that are executed, and maybe there's a greater amount of equality in this regard. We don't always know about the sort of ordinary decent criminals, the ODCs, who are executed, for theft or something like that, because they don't show up in the sort of sources that we're reading. There certainly are poor people who are executed for theft of an animal or goods, jewellery or material or anything else, but we also have lots of very wealthy people. Two people in particular that I tracked through the Restoration period, one called Loftus, who's a member of one of the great and good families of County Dublin. If you're familiar with Rathfarnham, you know their family home. They own large amounts of property in Wexford, and they have family members who had held the highest positions in both church and state. And one of those killed somebody in, I think it's 1663. He's found not guilty of murder, but he's found guilty of manslaughter, and he claims benefit of clergy, which is a sort of a get-out-of-jail-free card that everybody, or almost everybody, is entitled to use for certain crimes, but it's on the basis that you were branded afterwards, like I say, on that part of your left hand. And it's noticeable that after a point he gets his pardon, and then a few months afterwards it's quietly, the branding is quietly left, and he's not punished for that. But just 20 years later, a son of William Aston, who's a judge and therefore I think one of the higher echelons of Irish society, he kills a man on the South Keys in 1686, and probably more for political or religious reasons than ones of wealth, the Lord Deputy is not willing to pass a pardon for him because it would be so unpopular in the city. Primarily, I think, because James II has come to the throne, and the Catholics in Ireland are looking up and feeling very strong, and so maybe Aston represents Protestant Ireland, but whatever the nature of it, because of public opinion, essentially, he is executed for his crimes, and so that's very interesting. Even the method of execution, obviously, we will also see where class is very prevalent, in that nobles within Irish society, if they are to be executed, are virtually always given the privilege of an axe, which, if handled properly and the executioner is relatively sober, can be a very swift death and can be relatively painless. It's literally one blow and you're gone. Doesn't always go according to plan, but generally it does. Whereas commoners are usually executed with a rope. They're hanged in a slow hanging, which is a strangulation process. If it's a treason, it would be a hanging, drawing and quartering, and women are burnt. But for aristocrats who are to be executed for treason, again, it's just the axe. So there's certainly a great degree of class privilege going on there. So I think, just to wrap up, I think it's abundantly clear that class plays a large role in how Irish society sees itself and how it builds its criminal justice system and how this is administered most of the time. I think that's perfectly obvious, and I think, as you will kind of no doubt know about society today, and class and criminal justice, it reflects the society that it serves, and it stops when people want it to stop. It reflects that society. So that's all I have to say about that. Thanks very much for listening.